So David, with this whole thing with your non-suit being reinstated, is there any case law that permits this to take place?
No, there's no case law that there's case law that permits the judiciary to have what's called plenary power.
Okay.
Up to a certain time.
Okay. What is that time frame?
I think it's 30 days.
Okay.
It can be extended.
Okay.
If there's particular motions that are filed within that 30 days. The case law supports that the non-suiting party can request to reinstate the case.
So you could have requested to reinstate the case, but the opposing party cannot request that you reinstate your case.
No. I mean,
so
really,
this is really,
they can request, but there's no case law supporting that the opposing party can make me again pursue my original pleading.
Yeah, right? I know.
So how does that happen? So now I'm still pursuing equalized parenting.
So, but the thing is that my understanding is even though you've non-suited and he's wanted to reinstate, the judge has reinstated it. Is that correct?
The judge has reinstated me as a petitioner.
So that is absolutely incredible. And I think to me that at that point in time, it's not just the attorney can try whatever he wants to, I guess, if he wanted to be in defense of attorneys. But for a judge to permit this, I think that Judge Karen Crump should be reviewed somehow. She's going to just create novel case law right now out of thin air and create something that there is no case law for. I mean, I don't know.
Well, one of the comments that's on the record by Judge Karen Crump was that, quote, just because you don't like the report doesn't mean you don't have to pay for it. So that comment would be an assumption or speculation about why I refuse to have Alyssa Sherry involved further.
You don't want her involved because it's not professional.
In fact, the report wasn't admitted. Alyssa Sherry wasn't admitted as a witness.
Yeah.
So how would it be reasonable to come to that conclusion? You could only come to that conclusion if after exam of the report, after an appropriate cross-examination of the expert, cross-examination of the report, it was found that the report was valid, and that was simply the reason by exclusion.
Yeah.
But if you're not cross-examining the expert and you're not cross-examining the report, then you can't arrive to that conclusion.
Got it.
And from what I understand, the prior order for the custody evaluator was not a surviving affirmative relief. It was an agreed custody. It was an agreed order for a custody evaluation. So it's not a surviving affirmative relief of a non-suit. She stated that it was an enforceable order.
Yeah.
From my review of the case law, I don't agree with that.
Okay. So what I gather from our time that we've talked about this, especially on tape, but then like I said, other times that we've talked back and forth, if we could summarize, if I could summarize what I've learned, is that Dr. Alyssa Sherry, there are lots of reasons to question her as an expert child custody evaluator, and at least in your case, her report might be considered a lemon report of sort, not even worth the paper that it's written on. That when it comes down to opposing counsel, he has also done some manipulative tricks that's tried to prolong litigation. And
well, I mean,
I'll leave it at that.
Well, no, one of the questions you asked was, what does the judiciary's role in all of this? And if they're acting beyond guiding principle or case law, or they see that there's some dishonesty in the attorneys, that's their obligation to report that.
Right.
And
that would be something. If attorneys reported judges for misconduct, and if judges reported attorneys for misconduct or dishonesty or something like that, you would quickly weed out a whole lot of bad actors.
So, we had this case, we went through to summarize, we had this case, we went through temporary orders. At some point we attempted to mediate early on. There were some issues of injuries very early on, and we had additional temporary orders that actually increased the frequency because that issue was adjudicated of contact between our son and I. And then we had Fabricius as an expert witness testify on the issue of early attachment overnights. And in front of another judge, there were additional temporary orders that instituted overnights when our son was 16 months old. And certainly if there was some outstanding features evident at the time of that trial, even when Fabricius was there, it would have been there,
Right.
Which would have prevented the judge from adjudicating the decision to give early overnights.
Right.
So we were, over time on several occasions early on, I had been asking for some type of child custody evaluation.
Assuming that you had a child custody evaluator that was actually an expert and provided professional, qualified opinions with integrity and objectivity.
And it was denied. On more than one occasion, during the temporary order hearing, it was reinforced to have a case manager that had already been installed to utilize her services. And, but again, that was, those recommendations facilitated phone calls. But again, I think those recommendations from that professional advocated the same tribal culture separation of the child, from the parent. And
tribal culture being the culture of the family law attorneys, the family law judges, the Texas Family Law Foundation, which basically says that equal shared parenting or that equal parenting, parental equality, should not be the norm or should not be the starting point. Is that what I hear you saying? When you said tribal culture?
Yeah.
I mean, something that favors one parent over another?
I think that's a fair statement.
Okay.
And so then, on more than one occasion, there were summary judgments in 2021 and back in 2019 that weren't, by opposing counsel, that weren't supported. The summary judgment was based on there was no, evidence of any substantial material change.
Yeah.
Okay, well, those weren't supported.
Yeah.
Okay, so what does that tell you?
Yeah.
And then there was a Rule 11 agreement regarding, what's appropriate statements to the child from a parent. And then we had a hearing with Judge Art, and as I would say, as toxic as that hearing was, in my opinion, he did institute video calls. He restricted both parents from lunch activities, and neither could attend extracurricular activities on the other parent's time. But our son has more frequency of contact.
Yeah.
Then Alyssa Sherry's involved, and all of a sudden there's rulings by Judge Mousy that don't match the evidence that present. Mousy's recused. There's a ruling in which...
By the way, congratulations on that.
Yeah, there's...
I actually talked with the State Commission on Judicial Conduct about that, and they wanted to say, hey, can you send us this report? Because they were fascinated by the fact that she was recused primarily because of her association with the Texas Family Law Foundation, I believe, and her bias. Is that correct?
Well, that extrajudicial activities are a very important factor. Although the final decision was just biased with the specific case, although we were proposing as what's called per se, overall because of her membership, but the judge didn't reinforce that. But
that was a more objective, neutral judge that had a criminal background history. Is that right? So that he actually looked at evidence as opposed to making it up.
Yeah, I think that it was a fair hearing.
Yeah.
And so. And then there was an attempt to recuse Judge Art for similar reasons, as well as issues related to demeanor that I had previously encountered.
Yeah.
And toward me specifically.
Yeah.
And then there was the hearing with Karen Crump, which is the outcome we know, all within the presence of Alyssa Sherry's presence.